Friends, thank you for being here today. The Supreme Court of the United States has just delivered a judicial blow that has effectively ended the era of legal immunity for Donald Trump, plunging the former president and his entire defense team into a state of absolute and irreversible shock. We are witnessing a historic turning point that almost no one inside the Trump camp believed would actually happen. For years, the strategy has been to delay, appeal, and trust that the slow gears of justice would run out the clock. But as of this morning, time has not only run out, it has been destroyed completely. The highest court in the country has issued a single-line order that carries more weight than 1,000 pages of legal briefs. Petitioned and denied. With those two words, the final avenue of appeal has been closed. There are no more motions to file. There are no more emergency stays to request. The legal road has officially ended, and Donald Trump is now staring into the abyss of immediate accountability. Before breaking down the terrifying mechanics of this final ruling and explaining why reports indicate that Trump is entering a state of total panic at Mar-a-Lago, take a brief moment to click the subscribe button, turn on notifications, and hit the like button on this video. If you are looking for the unfiltered truth about these clashes in the courts, including details that mainstream media outlets often overlook, you are in the right place. Join our rapidly growing community now so you do not miss a single update as this extraordinary enforcement phase begins. Let us analyze the structure of this catastrophic ruling in a decision that legal historians and constitutional scholars are already describing as the most momentous rejection of a former president in United States history. The Supreme Court has refused to hear Trump's final appeal regarding his claim of absolute presidential immunity. This was his last desperate play, the argument that a president cannot be prosecuted for any act committed while in office. Trump's lawyers had bet everything on this. They believed that even if they lost in the lower courts, the Supreme Court, with its conservative majority, would at least grant them a hearing, a process that would consume months or even years. Instead, the justices rejected the case immediately. They did not even schedule oral arguments. They simply let stand the lower court ruling, a ruling that clearly established that a former president is not a king and is subject to the criminal laws of the United States like any other citizen. This is not a routine denial. It is a complete repudiation of the unitary executive theory that Trump has used as a shield for decades. The immediacy of the consequences is what makes this situation so volatile. Usually, when the Supreme Court rejects a case, there is a procedural grace period before the lower court's mandate is issued. Basically, the formal order to restart the trial or execute the sentence. But in a move that has stunned legal observers, the Supreme Court ordered the judgment to take effect immediately. In legal terms, immediately means right now. It means there is no pause. The stay that was halting the criminal trials has dissolved instantly. Special counsel Jack Smith is now free to move immediately to trial. The judge in New York is free to execute the sentence. The legal dam is broken, and the floodwaters are rushing in all at once. Trump woke up this morning believing he had months of maneuvering left. He goes to bed tonight, knowing that jury selection could begin as soon as next week. The atmosphere at Mar-a-Lago is reportedly one of apocalyptic confusion. Sources close to the former president describe him as incredulous, unable to process the fact that the judges he appointed himself, Gorsuch, Kavanaugh, Barrett, did not step in to save him. He viewed the Supreme Court as his ultimate safety net, his last line of defense against the deep state. The realization that the court has abandoned him is a psychological blow that cuts deeper than any election loss. We are hearing reports of shouting matches between Trump and his top lawyers, with Trump accusing them of failing to frame the arguments correctly. But legal experts agree that it was not the lawyers, it was the law. There simply is no constitutional basis for the idea that a president can commit crimes with impunity, and the Supreme Court was not willing to destroy its own legitimacy to protect a single man. This ruling also triggers a massive financial crisis for the Trump campaign. Until now, they have been raising millions of dollars on the promise of fighting the witch hunt all the way to the Supreme Court. They told donors that the High Court would finally vindicate them. That narrative has just been vaporized. How do you ask a donor for money to fund an appeal that has already been denied? Fundraising emails will have to change. From help me fight to help me pay my legal bills before I go to jail? That is a much harder sell. We are already seeing signs of donor fatigue with major contributors quietly closing their checkbooks. They recognize a lost cause when they see one. The Supreme Court strategy was the only strategy they had. Now that it is gone, the campaign is effectively a zombie operation. It walks, but it is dead inside. Let us delve deeper into the specific language of the lower court ruling, which is now the law of the land. The Court of Appeals for the District of Columbia Circuit drafted a scathing opinion that dismantled every one of Trump's arguments. They wrote that President Donald Trump has become Citizen Trump with all the defenses of any other criminal defendant, but that any executive immunity that may have protected him while he served as president no longer protects him against this prosecution. By refusing to hear the appeal, the Supreme Court has effectively endorsed this language. They have cemented the principle that no one is above the law. This precedent will echo through history, but for Trump, history books are the least of his concerns. His concern is the very real possibility of a federal prison cell. Without immunity, the evidence against him in the January 6th case and the classified documents case is overwhelming. His defense was never, "I did not do it." His defense was, "I was allowed to do it." That defense is now dead. The panic in Washington is not limited just to Trump's inner circle. It is spreading through the Republican establishment. For months, Republican Party leaders have been dodging questions about Trump's legal troubles, saying, "We have to let the appeals process run its course." It was a convenient excuse to avoid taking a stand. Well, the appeals process has already run its course. It has ended. Now every senator and congressman will have to answer a simple question. The Supreme Court has paved the way for the trial of a former president. Do you support the rule of law, or do you support a criminal defendant? They can no longer hide behind procedural delays. The binary choice is here. We are seeing senators running from reporters in the hallways of the Capitol because they do not have an answer. They are terrified of alienating the Trump base, but they are equally terrified of tying themselves to a convicted felon. George Will, the conservative commentator who has observed the degradation of the Republican Party with growing alarm, went on air moments ago to contextualize this moment. "This is the end of the road," Will stated. The fiction that Donald Trump is a victim of a corrupt legal system has been shattered by the very institution conservatives revere, the Supreme Court. The denials, the delays, the obfuscations, everything has crashed against the wall of reality. The Republican Party must now decide if it is a party of law, an order or a cult of personality dedicated to the protection of the lawlessness of one man. The court has done its duty. Now the voters must do theirs. I want to pause here and ask you, is the Republican Party facing an impossible choice, or is the path forward clear to you? Let me know what you think the party should do in the comments below. The legal mechanics of what happens next are brutal in their efficiency. The case returns to Judge Tanya Chutkan in Washington, D.C. Judge Chutkan has made it clear that she intends to bring this case to trial as quickly as possible. She has previously stated that the public has a right to a speedy trial just as much as the defendant. We could see a scheduling conference scheduled within 48 hours. The trial date, which had been vacated while the appeal was pending, will return to the calendar. And because the Supreme Court waited until now to rule, the timing falls directly in the middle of the general election campaign. Trump will be forced to spend his days in a courtroom in Washington, D.C., listening to testimony about his attempt to overturn the election instead of campaigning in key states. The image of a presidential candidate sitting at a defense table day after day is a political nightmare that no campaign manager can spin, but the danger for Trump goes beyond scheduling. The finality of this decision means that the evidence gathered by the special counsel is now fully admissible. There are no more arguments to be made about executive privilege protecting his conversations with advisors. The courts have ruled that privilege vanishes in the face of a criminal investigation. This means witnesses like Mark Meadows, Mike Pence, and others can be forced to testify without restrictions. Trump's greatest fear has always been his own inner circle turning against him. With the immunity shield gone, there is no legal reason for them to remain silent. They are no longer protecting the office of the president. They are protecting themselves from perjury charges. The psychological toll on Donald Trump is the unpredictable factor in this scenario. He has operated his whole life on the principle that he can always cut a deal. He can always appeal. He can always find a way out. He has never faced a situation where the door is truly welded shut. This is creating a level of cognitive dissonance that is dangerous. Reports from staff indicate that he is oscillating between deep depression and explosive rage. He feels betrayed by the system he thought he controlled. This mindset makes him volatile. We are likely to see even more extreme rhetoric on social media, attacks on judges, attacks on prosecutors, and perhaps even calls for civil unrest. The judicial system is preparing for this. Marshals are being deployed. Security is being reinforced. The system knows that a cornered animal is the most dangerous, and Trump is more cornered than he has ever been in his life. Let us look at the catastrophic scenario for Trump. With the appeal denied, if he is found guilty, he faces mandatory prison time. The charges against him, conspiracy to defraud the United States, obstruction of an official proceeding, carry penalties of up to 20 years. Sentencing guidelines for a defendant with his profile who has shown no remorse and has actively attacked the court would likely recommend significant incarceration. There is no house arrest at Mar-a-Lago for these types of crimes. Reportedly, the Secret Service has already begun preliminary discussions with the Bureau of Prisons regarding the logistics of housing a former president. Just think about that. The Secret Service is planning how to protect a former president inside a federal penitentiary. That is where we are. That is the reality the Supreme Court has just unlocked. It sounds like science fiction, doesn't it? Do you believe we will actually see a former president behind bars? Or will the system blink at the last second? Give me your prediction. The media landscape is currently in a state of collapse as they attempt to process the speed of this development. The narrative has shifted from will he be tried to when will he be convicted. The certainty of the trial changes everything. It changes the polls, it changes the donor calculus, it changes the vice presidential selection process. Who wants to be the running mate of a guy who might be inaugurated from a prison cell? The toxicity of the Trump candidacy just increased exponentially. We must also consider the reaction of the deep state narrative pushers. They are already presenting this as the ultimate proof of conspiracy. But this argument rings hollow when the court is dominated by conservatives, 3 of whom were appointed by Trump himself. If the deep state controls Clarence Thomas and Samuel Alito, then the term has lost all meaning. This is the glitch in the conspiracy theory. It cannot explain the fact that strict constructionist judges simply read the Constitution and found no clause that says the president can do whatever he wants. Do you buy the deep state argument, or has that theory officially collapsed with this ruling? Tell me in the comments. As we move into the next phase, the enforcement phase, things are going to get ugly. Trump is likely to try to fire his lawyers again. He will try to file frivolous motions to delay the start date. He might even try to boycott the trial. But Judge Chutkan has the power to compel his attendance. She can issue an arrest warrant. The image of federal marshals escorting a former president into a courtroom is something the country has never seen, but we are inching closer to it every day. The Supreme Court has effectively said, "We are done. It is your problem now, Judge Chutkan," and she is ready to act. The silence from the other Republican candidates is also telling. Nikki Haley, Ron DeSantis, before they withdrew, all trod carefully. But now we might see a shift. If Trump is guaranteed to be in court during the primaries and the general election, the argument for a Plan B becomes much stronger. I am the candidate who is not going to jail. It is a pretty compelling slogan. Party brokers will be meeting in back rooms this week, terrified that they are sleepwalking into a historic landslide defeat. The financial pressure is tightening in coordination with the legal pressure. Jury consultants, expert witnesses, travel for the legal team, housing for staff in D.C. Cost millions of dollars a month, and the Republican National Committee has already signaled they are hesitant to pay legal bills for criminal cases. Trump faces a liquidity crisis at the exact moment he needs it most. The denial by the Supreme Court seals his fate regarding the venue. He will be tried in the city he tried to disenfranchise. There's a poetic justice in that, but for Trump, it is a nightmare. He believes the jury will be rigged against him and he will scream it from the rooftops, but the law is the law. You are tried where the crime was committed, and the crime of attempting to overthrow the government occurred in Washington, D.C. The ripple effects of this decision will touch every part of American life. It reaffirms the stability of our institutions, but it guarantees a chaotic year. The election of 2024 will be a referendum not just on policies, but on the rule of law itself. Trump will run as an outlaw hero, a martyr. Biden will run as the defender of institutions. The Supreme Court has set the stage for this clash. By stepping back, they have pushed the country toward the most volatile election since 1860. And what about the voters who are just tuning in? The average American who does not follow every court filing. They are about to see breaking news banners that say, "Supreme Court denies Trump appeal." That penetrates the noise. That sounds final. It cuts through the spin. It tells the low information voter that Trump lost, and in America, nobody likes a loser. The aura of invincibility is the most important asset a strong man has. Once that is punctured, once the courts start treating him like a common criminal, the spell begins to break. Now, we must also confront the most complex and unprecedented question that lurks on the horizon, a scenario that constitutional scholars have debated in theory but never imagined would become reality. What happens if Donald Trump is convicted by a jury of his peers but still manages to win the election? This is the doomsday scenario for the American legal system. The Constitution does not explicitly forbid a convicted felon from serving as president. We could theoretically see a situation where the president-elect is scheduled for sentencing on the same day as his inauguration. This opens the door to the ultimate legal absurdity, the self-pardon. Trump has long claimed he has the absolute right to pardon himself. If he regains the Oval Office, his first act could be to wipe away his own federal convictions with the stroke of a pen. This would provoke a constitutional crisis that makes the Watergate scandal look like a minor misunderstanding. It would force the Supreme Court to decide if the president is truly above the law in the most literal sense, creating a paradoxical loop where the executive branch consumes the judicial branch. This possibility alone will drive voter turnout to historic levels as the election becomes a direct ballot measure on the sanctity of the justice system itself. This is the big question I want you to answer. Should a president have the power to pardon himself? Is that a feature of the presidency or a bug in the Constitution? Start a debate in the comments section right now. Furthermore, we need to talk about the inevitable split-screen reality that is about to dominate the airwaves. On one side of the screen, you will see Trump at rallies, surrounded by cheering crowds, flags, and music projecting strength and defiance. On the other side, you will see sketches from inside the courtroom depicting a tired, slumped figure listening to hours of damaging testimony about his conduct. This visual contrast is devastating. It strips away the mystique. It is hard to project the image of a strong man when you are subject to the schedule of a judge who can hold you in contempt for speaking out of turn. The independent voters, the suburban women in Pennsylvania, Michigan, and Wisconsin who decide elections, they recoil from chaos. They want stability. The prospect of a president trying to run the country from a courtroom or, worse, a prison cell, is a bridge too far for the moderate middle. The Trump base will stay loyal, that is a given, but elections are won on the margins, and the margin for error just vanished. We must also consider the scorched earth tactics that are likely to emerge from the Trump legal team now that the appellate avenue is closed. Expect to see a strategy of total delegitimization. They will not just attack the case, they will attack the very concept of the jury system. We are already seeing the groundwork being laid with claims that a Washington, D.C. jury is inherently illegitimate because of the city's political demographics. This is a dangerous game. By attacking the jury system, they are attacking a foundational pillar of American democracy that dates back to the Founding Fathers. It is an assault on the civic duty of ordinary Americans. When you tell half the country that the justice system is a weaponized fraud, you're not just trying to win a case, you're trying to break the system so that it can never judge you. This rhetoric invites instability and erodes the social contract that holds the nation together. Finally, do not underestimate the international dimension of this weakness. Foreign adversaries like Vladimir Putin and Xi Jinping are watching this chaos with glee. They see a distracted America, consumed by internal legal warfare. They calculate that a United States paralyzed by the prosecution of its former leader is less likely to respond forcefully to aggression in Ukraine, Taiwan, or the Middle East. The domestic legal crisis creates a vacuum of leadership on the global stage. Allies are nervous. They are asking if American commitments can be trusted when the political system is so fragile. This trial is not just a domestic legal matter. It is a national security vulnerability. The world is holding its breath, waiting to see if the American experiment will survive its greatest stress test since the Civil War. The stakes could not be higher, and the clock is ticking loudly. So this is the deal. The Supreme Court has spoken. The final appeal is dead. Donald Trump is out of options, out of time, and out of excuses. The legal shield he has wielded for 50 years has been shattered. Now he is naked before the law. The trial is coming, the evidence is coming, the witnesses are coming, and there is nothing, absolutely nothing he can do to stop it. The system has finally caught up with the man who thought he could outrun it forever. This is the moment the truth comes out. We are about to find out if the American experiment can withstand the stress test of trying a former president. The coming weeks will be full of noise and fury, but the underlying reality is silent and immovable. The law applies to everyone. Make sure you are subscribed to this channel. We are going to cover the trial day by day. We will break down the witness testimony, the evidence, and the frantic maneuvers of the defense. The mainstream media will give you the headlines. We will give you the truth. The era of delay is over. The era of accountability has begun. Do not look away. History is happening right now. And before you go, tell me, are you optimistic about the future of the justice system after today? I read every comment. Thanks for watching.